I'd like to read from my recent appeal to the First Circuit of the Federal Court in regard to the suit that I filed back in November. It's called Mary Maxwell versus President of the United States. And it was a request that the court use a restraining order against the president, that he not breach the part of the Constitution that says only Congress can declare war. So that case was dismissed, partly for lack of justiciability and also for lack of standing by me. And in my appeal, I have more to say to prop up my case. Justiciability. The New York Review of Books of November 30th, 2017, contains a cartoon of President Trump threatening North Korea, quote, with a fire and fury like the world has never seen, unquote. The front cover of the January 18th, 2018 New York Review of Books has a cartoon of Trump putting his hand near the nuclear button with the caption, "Who will stop him?" That is the question of my lawsuit, to which I reply, the third branch of government. There can be no question that this case is justiciable. Chief Justice John Roberts wrote for the U.S. Supreme Court in Zivotofsky v. Clinton, that's a 2012 case, "It is the responsibility of the judiciary to decide cases properly before it, even those it would gladly avoid." It can be presumed that the court would be glad to avoid this case, as it would be a bold undertaking to interfere with an executive decision to strike an enemy of the United States with nuclear missiles. What if the court ordered the president to refrain from starting a war, and the consequence was that the enemy struck first and killed many Americans? Another question is, what if the president's strike with fire and fury results in military attacks and counterattacks among multiple countries? Those who might survive would do what is customarily done after a military debacle and ask, how could this have been avoided? Where did we make the wrong judgment? The ghost of James Madison can answer that last question with ease. I believe he would say, "You 21st century people did not accept the wisdom of our day. We could see in the 18th century that it is inherently dangerous for a president or a king to have the sole personal authority to start a war. Such is human nature that he could be acting selfishly. For one thing, someone could be holding a gun to his head saying, 'Start the war or we will kill you.'" The framers understood moral hazard and did a fine job of creating safeguards against it, including by placing checks and balances among the branches of government. In regard to war, since the people would have to pay for it, both in money and lives, the people, via their elected representatives, were given the power to declare it or refrain from it. Thus, the court, in regard to my case, is on very safe ground, interfering with the president's threat to start a nuclear war on his own. Article 1, Section 8, Clause 11 of the Constitution could not be more specific, and the reasons for it, recorded in the notes of the 1787 Constitutional Convention, could not be clearer. A U.S. president cannot make the decision to start a war without a declaration from Congress. This fact is incontestable. Only an amendment can change it. The undesirability of war. Perhaps it need not be said, but my appeal would be incomplete without it. Peace is a profound value, and war is the cause of great sorrow. The preamble of the UN Charter says, quote, "We, the peoples of the United Nations, determined to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrow to mankind," etc. Nuclear weapons are particularly sorrow-engendering, always inflicting massive casualties on civilians. The Pentagon admits that we have fired nearly 1 million rounds of depleted uranium, DU, in Middle Eastern countries, allegedly causing birth defects among locals and bringing about, in a major way, the loss of America's prestige in the world. As the DU vaporizes on impact, it also harms American soldiers. As reported in the book The Sorrows of Empire by the late Chalmers Johnson, the U.S. Department of Veterans Affairs in 2005 was compensating 168,000 disabled soldiers who served in the Gulf War of 1991 for injuries caused by DU. Among birth defects of their children were fused fingers and missing eyes. Yet we hear President Trump boasting he will send fire and fury like the world has never seen, implying that there are even worse weapons than the ones the public knows of. The War Powers Act is insufficient or obsolete. In 1973, Congress legislated an answer to the question, what if the need for war is urgent and Congress is not available to debate it in time? The War Powers Act allows the President to take military action on his sole authority for a maximum of 60 days while awaiting congressional authorization. This may have suited the needs of the time when there was no stated prospect of the United States launching a first strike nuclear attack. But beginning in 1990, the policy changed when commanders in the field were given the option of using tactical nukes. To this day, the governing rudiments of this policy are not known by the citizenry. On September 19, 2017, the magazine Foreign Policy published an article titled, "Like I was saying, tactical nukes are on the table for use against North Korea." The author of that article, Thomas E. Ricks, pointed to recent talks between U.S. Defense Secretary James Mattis and Republic of Korea's Defense Minister Song Young-moo, during which Mattis stated to reporters, "We have open dialogue with our allies on any issue they want to bring up. We're not only friends, we're trusted allies, and we bring up issues with one another." An American reporter then asked, "Sir, there's a chance that small tactical nukes might be redeployed to the Korean Peninsula?" Mattis says, "No, I said that we discussed the option, but that's all the further I want to say." Both the citizenry and Congress are recipients, if they are lucky, of information about war plans from the executive. But per the parchment, they should be the authors, not recipients. It is also true that the public does not know who the enemy is. Representative Tulsi Gabbard of Hawaii has sponsored a bill, and then it was mirrored in the Senate by Senator Rand Paul, entitled the Stop Arming the Terrorists Act. The cause of the bill is that our military is sending resources to the Islamic State whilst we are fighting them. Such a situation is surreal. Nevertheless, the mainstream media will slap down, if not smear, anyone who raises a discussion about this. The lack of understanding of the role of NATO. In addition to North Korea, we read about a possible confrontation involving Russia and Iran, with hints that NATO would make the decision. I believe the signing of the Washington Treaty in 1949, which brought forth the NATO, was treasonous in that it entails the U.S. military taking orders from parties outside the United States. Article 5 of that NATO charter states, I quote, "The parties agree that an armed attack against one or more of them in Europe or North America should be considered an attack against them all, and consequently they agree that if such armed attack occurs, each of them, in exercise of the right of individual or collective self-defense, recognized by Article 51 of the Charter of the United Nations, will assist the party or parties so attacked by taking forthwith, individually and in concert with the other parties, such action as it deems necessary, including the use of armed force." Unquote. Thus, we are a signatory to an official document that contradicts Article 1, Section 8, Clause 11 of the United States Constitution. No case is presently before this court, as far as I know, with regard to the issue of NATO, but my case is before this court asking for relief in regard at least to Congress's sole right to declare war. If the Congress grants my request for an injunction, that could have the salutary effect of calling people's attention to the further issue of the unconstitutional nature of our NATO membership. The place of law in society. In my 4 years of law school in Australia, I never once heard a lecturer address the question, what is law? Or, where does law fit in a nation's culture? The emphasis was always on black letter law, statutes, the common law, the Australian Constitution, and especially jurisprudence, including judicial doctrines and tests. It was as though the law simply is. We students should learn how to find it, to track it down. But having been born and raised in Boston, I know some other things about law. I know that it is an ideal, and that ideals have a major psychological function. They are the symbols that both inspire and unite people. The Bill of Rights, for example, has often set the pace for citizens' understanding of how society should work. Having also been a student of evolutionary biology, I know that law was a feature of Homo sapiens from the earliest days. The evolved emotions of shame, guilt, and righteous anger make self-restraint possible, and these contribute to the enforcement of society's rules. Children can be brought into the society's understanding of right and wrong by mere looks of approval or disapproval and intonations of voice from their parents. Granted, the instinct to conform and obey can be a menace or a comfort when the odds against the individual are insurmountable. I think that today a premature calculation of hopelessness about war or about government's honesty is causing people to give up. Law also has a relation to the biological fact that we are a hierarchical species. All persons recognize that some individuals are above them and some below. As a result, we frequently let the higher ones exploit the lower. Law is the only way to counteract that phenomenon. Our Constitution also helps form the tribal identity of Americans. This supports what in other cultures may seem ridiculous, the patriotism of standing up to protest government actions, as I do today, to safeguard both personal dignity and the national interest. Evil. The spirit of the law should also make us less timid about recognizing evil. I quote from a poem anonymously written entitled The Ogre that appeared in a book, The United Service, Volume 2 from 1889. Oh, shame, what mockery! For lo, he, that is the ogre, rouses fresh at morn, bursts the weak bonds with grin of scorn and fierce derisive glee, sounds his defiant whistle shrill, and on his way, more fiendish still, rushes triumphantly. O law, where is thy boasted might? Is it but idle breath? Will the stern majesty of right bow terror-struck to death? The answer at present is yes. That is, we are enabling the defeat of law in the face of evil. What fools we be. I asked above, what if President Trump's fire and fury started a multi-nation war? Media says Trump has been consulting Henry Kissinger, who is no pacifist, about foreign policy. It is notable, thanks to the new weaponry, that the biosphere itself would not be spared. I've lost my page 5 and I have to go get it, so we'll have to cut it there. It's down on the lower left, second to the bottom shelf, lower left. Page 5. Yes, this is it. So I'm going to repeat just slightly. After I finished reading the poem, Okay? Shall I go after the poem? I'll start now. The answer at present is yes. That is, we are enabling the defeat of law in the face of evil. What fools we be. I asked above, what if President Trump's fire and fury started a multi-nation war? Media says Trump has been consulting Henry Kissinger, who is no pacifist, about foreign policy. It is notable, thanks to the new weaponry, that the biosphere itself would not be spared. The survivors of a World War III would likely be left with an ill and damaged planet. Standing. We need all hands on deck. Anyone who can help stop the collapse of the United States should contribute his or her bit. It may require sacrifice, but many would do it out of gratitude for the incredible blessings we have enjoyed from the Constitution. I am one of those grateful persons, willing to pitch in. Hence, I have standing in this court case, as would any concerned and informed citizen. I argue here that I also have standing under Lujan v. Defenders of Wildlife, 1992. There we find the test, a citizen can sue if he or she is in imminent danger, which is indisputably the case with respect to one Mary Maxwell, not to mention the respected jurists analyzing this case. Congress has provided in recent statutes concerning environmental matters that a citizen can plead for the community, even when he or she is not personally affected. My case, besides being about the war power, is environmental. My cri de coeur is, don't nuke Mother Nature. The role of the judiciary. On the social landscape, a judge stands out as a moral of morality because he or she virtually is the law. We respect and honor the judge as a matter of course, which gives that person extra scope to act resourcefully in a crisis. A sensible law maxim states, boni judicis est ampliare jurisdictionem. A good judge looks around for more to do. The court sometimes chooses to rule narrowly. I recognize that conservatism has its place, but necessitas non habet legem. Necessity has no law. Creative work may be called for. Still, the happy fact is that the U.S. Supreme Court's ruling in Youngstown v. Sawyer, the 1952 steel mills case, confirmed that Congress has the sole right to declare war. No subsequent case has reached the highest court. Massachusetts v. Laird was dismissed, so the ruling stands. The U.S. Court of Appeals of the First Circuit erred in dismissing the 2003 case of Doe v. Bush. There, some soldiers and parents of soldiers asked the court to support Article 1, Section 8's provision that the Congress has power to declare war. Judge Sandra Lee Lynch wrote, an extreme case may arise, for example, if Congress gave absolute discretion to the president to start a war at his or her will. Plaintiff's objection to the October resolution does not, of course, involve any such claim. Nor does it involve a situation where the president acts without any apparent congressional authorization. President Bush planned to invade Iraq without valid grounds. Huge groups protested, to no avail. As many as 500,000 Iraqis died, and their culture was ruined. Should the court be held responsible for the invasion? No, clearly the legislative branch should be held responsible. It evaded its duty. But in an intelligent nation, was no other solution available? The plaintiffs turned to the third branch. The court did not have to say yes or no to war, but only restrain the president from violating the Constitution. Instead, it dismissed the case. The soldiers in Dovey Bush asked for their appeal to be heard on an emergency basis, and I similarly request that my pleadings be undismissed expeditiously, and I ask for a jury trial. Respectfully submitted, Mary Maxwell, February 2nd, 2018, in Concord, New Hampshire.